Thomson Reuters v. Ross is not a case we covered in depth, but it is actually very important for fair use, so we should look at it a little more. If you remember, really the only thing I said about it was that you should stop using it as some kind of precedent against generative AI because, as Judge Bebas said, Ross didn't make a generative AI. It works completely differently. It doesn't work like ChatGPT or Stable Diffusion or all of those. So basically, stop using it. Stop throwing it in our faces as if it proves your point, because it doesn't. And maybe it worked, because I haven't seen that as much yet, but it was a bad decision for fair use. And so it is worth following their appeal in the Third Circuit, that hopefully they can get that overturned and get another good decision for fair use. There just hasn't been a lot to report on it until a few weeks ago, when they dumped 10 Amicus briefs on us. Just out of the blue, nothing happened, and then boom. And that was way too much to cover. And we don't even have them all anyway. They didn't put all the documents in Pacer. Now, of course, you can see them other ways, like the EFF put theirs on their own website, but it's still just too much. But thankfully, Project Disco recently put up this very good summary of the briefs, what they are and what they say with regards to fair use. And they say the Amici represent a wide range of perspectives from academics and technical experts. And then they name them to nonprofit organizations, the Authors Alliance, the EFF, the American Library Association, Association of Research Libraries, Internet Archive, Public Knowledge, and PublicResource.org, as well as the Foundation for American Innovation, to technology companies Ciceri, Dispute Resolution AI, the Free Law Project. Shout out to the Free Law Project, because that's where I get the RSS feeds through Court Listener. And that's an open source project that really opens up citizen access to all the courts, which we should be getting naturally, because we're not supposed to have secret courts. None of this is supposed to be behind, shadowy, that you have to go way out of your way to find out. No. So kudos to the Free Law Project and everything they do. Juristine Legal Technology Group, Paxton AI, Trellis Research, CCIA, Chamber of Progress, and NetChoice. Yeah, that's a lot, but basically what they say is that Westlaw's Headnotes are not entitled to a strong copyright protection, so Ross's use of them to train an AI-powered legal research tool constitutes fair use. So, talking about the district court decision, Judge Bebas largely sided with Thomson Reuters, granted them partial summary judgment on direct copyright infringement. Ross Intelligence infringed 2,243 Westlaw Headnotes, and both the Headnotes and Westlaw's key number system met the minimum threshold for copyright protection. The first and fourth factors of fair use, purpose and character, and market effect, favored Thomson Reuters, while the second and third, nature and the amount used, favored Ross, but not enough to excuse the infringement. And that just kind of goes to show you what a subjective balancing act fair use is. A lot of times, if you really want to make something that's clearly fair use not to be fair use, they give you plenty of outs for that. So before you get into fair use, there's the question of, do you even have a copyright to begin with? And several of the Amici, including the EFF, said that Westlaw's Headnotes failed to meet the originality threshold set under Feist v. Rural. And if you remember, we talked about that one. That was the one where they took the phone listings from the phone company, put it in their own listing, the phone company sued, and lost because that wasn't a thing you could copyright. And the court said, and I quote, "The selection and arrangement of facts cannot be so mechanical or routine as to require no creativity whatsoever. The standard of originality is low, but it does exist." And so that's what they're saying. These headnotes are factual statements that mirror judicial opinions, which are public domain. And since all you're doing is pulling the facts out of these public domain judicial opinions, they lack the creative expression required for copyright protection. And they also talk about the merger doctrine, which we've talked about before. And it has to do with the dichotomy between ideas and expressions. You cannot copyright ideas. You can only copyright expressions. But merger is when the idea and the expression are so strongly linked that they can't be separated. And when that's the case, you don't get copyright protection for it. All right, so getting down to fair use and looking at the four factors, starting with factor 1, the purpose and character of the use. And all of the amici argued that they meet all four standards. Starting with the first one, this is basically how transformative it is. So you have the Authors Alliance and others saying that Ross's use was highly transformative. They trained its AI system to understand legal language and improve search functionality. This purpose differs fundamentally from Westlaw's use of the Headnotes as human-readable summaries. And they cited ones we've talked about, Authors Guild v. Google and Sega v. Accolade. So in Authors Guild, the Second Circuit held that the creation of a full-text searchable database is quintessentially transformative use. Likewise, in Sega, the Ninth Circuit determined that copying necessary to develop a competing non-infringing product served a legitimate, essentially non-exploitative purpose. And by the way, if anyone comes at you with, well, that's not the Third Circuit, that's a totally different circuit. Circuits are supposed to take judicial notice of how other circuits have ruled. And if it's just one circuit, that might be one thing, but when you have multiple circuits, like we do here, saying the same thing, they're supposed to take judicial notice of that. When they don't, it's called a circuit split, and that's when it needs to go up to the Supreme Court. But if you've got multiple other circuits saying the same thing, you're supposed to go along with that. Because we want things to be consistent across the country. We don't want the federal laws to mean one thing in one part of the country and a different thing in a different part of the country. The whole point of them being federal is that they apply equally countrywide to everyone everywhere. Alright, so factor 2, the nature of the work. Westlaw's headnotes are factual and constrained by the need for accuracy, giving them at most a thin layer of copyright protection, meaning you wouldn't have to do much to them to make them transformative under factor 1. The EFF and Curiae argue that the district court gave insufficient weight to this factor and that the headnotes lack significant creative expression, far from the core of intended copyright protection, as the Supreme Court held in Campbell, which we've also talked about. Campbell was the one where Two Live Crew grabbed all those samples from Roy Orbison's Pretty Woman, and so there was a lawsuit, and they were like, no, that's fair use, they can do that. So moving on to factor 3, the amount and substantiality of the portion used. And they like throwing around big numbers like 2,243 without putting them in any sort of context or proportion. So they can say, oh, look at how much it is. That's a lot. That's too much. But one of the amici points out that that's only a small subset of Westlaw's overall database, and it was used solely to train its AI model. And they cite Oracle v. Google, one we've talked about many times. The Supreme Court held that copying may be permissible when it is tethered to a valid and transformative purpose, as it is here. And finally, factor 4, the effect on the potential market. This is something else we're really going to have to fight about, because we'll see exactly the same kind of thing that they've been trying to do in the other AI cases, totally warp factor 4 to mean that if you so much as make a competing product, then you fail factor 4. No, that's a market substitute, not merely a competing product. If I use AI to write a book, and that book goes on the shelf and competes with your book because it's a fantasy book and you're a fantasy writer, that's not enough. It's not enough that it merely competes. The expression has to be close enough for it to be a market substitute, meaning that you can just pick one or the other. It doesn't matter. They're basically equivalent. We talked about that in our coverage of the ridiculous Warhol decision, where the Supreme Court looked at the original photo and the Warhol and went, that's the same picture. And as Kagan pointed out in her dissent, if you're a magazine editor, are you going to say, yeah, that's pretty much the same, it's a coin flip. There's no real reason why you would choose one or the other. That's what this is supposed to be. And so here, the amici reject the district court's conclusion that Ross's system harmed Thomson Reuters' market. Ross's AI does not output or display Westlaw's headnotes, and competition in the legal research market is not cognizable under copyright law. Just because they're competing with you doesn't mean you can stop them. And they cite another we've talked about, Sega and Connectix. Legitimate market competition is not an infringement. A use that simply enables the copier to enter the market for works of the same type as the copied work is not unfair. And then you have several briefs that make some more miscellaneous arguments, such as how the court conflated AI training with actually generating the content. Ross's system is a functional, search-oriented model that transforms copyrighted text into mathematical vector embeddings to improve semantic understanding, not a generative system that reproduces content. Misclassifying AI training as infringing reproduction could stifle technological progress and innovation in legal research tools. And again, under the Constitution, the only justification for copyright is to promote the progress of science and useful arts. And if you're stifling technological progress and innovation, you're not doing that. You're doing the opposite of that. And therefore, your copyright claim is invalid. Extending copyright protection to short factual summaries of judicial opinions could privatize access to the law, which is exactly the opposite of what a lot of these groups, like the Internet Archive and the Free Law Project, are trying to do, undermine the public domain, and restrict competition. Ross's technology promotes accessibility to judicial opinions and fosters competition in the legal research market, benefiting smaller firms, independent practitioners, and the public. Yeah, if you're a small firm or you're just a regular schmo like me, how is it that I have access to all the legal stuff I read out? Well, it's largely thanks to the Free Law Project. And you start restricting all of this, like they're doing with Thomson Reuters, then you undermine the ability of the small firms and of the individuals to do their own legal research and pass the benefit of that on to others. And that is exactly what fair use is supposed to stop. Because there, you're getting into some really important constitutional rights, not just freedom of speech that I've been harping on, but it goes into 4th, 5th, and 6th Amendment rights as well. All of this deserves to be public. I mean, I would go so far as to say that unless you've got some good reason for sealing proceedings from the public, if it's a case where the public can go into the gallery and watch the court proceedings, then the court should live stream it. Live stream all of these. The circuits have started doing that. The Supreme Court has done that, at least with audio. They don't put themselves on video, but okay, we've got the audio at least. But for a lot of these, they're just inaccessible. And so we've seen cases where journalists have gone in, sat in the gallery, and either completely misinterpreted or deliberately lied about the proceedings, and we didn't find out about it for months until someone was finally able to get their hands on a transcript and get it out. And so when you've got either incompetent or dishonest journalists, we need a system where we can immediately say, wait a minute, that's not what happened. Think about the Kyle Rittenhouse trial. If that thing wasn't live streamed, think of how much misinformation would still be out there. And think about how much of the stuff that the mainstream media is still trying to say about Kyle Rittenhouse that we know to be a lie because we've got the video of the court proceedings. And think how awesome it would have been to see the proceedings in all the Donald Trump trials. They didn't want us to see any of those, did they? There were people petitioning, people on both sides. They're like, yeah, let us see it. But we couldn't, and so when the news media reported on it, how do we know what we can believe? The more open the law is, the more all of us benefit from it. So that's what this one goes into, not just free speech, but that very vital aspect of how our judicial system is supposed to work. So we don't have a response brief from Thomson Reuters. It'll be interesting to see what they have to say, but that's not until the 21st. And then usually the way it goes is that Ross will get a chance to do a reply brief, and then we'll probably have some sort of proceedings in front of the court, which they might video since a lot of the circuits have been doing. We'll just see how it goes, but for now, thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.pagosity.tv. Keeps me doing this for anything, even the tiniest little one-time donations with cryptocurrency, all the way up to regular support, keeping me going and keeping you getting these videos early and ad-free and other benefits. So please check that out. Thank you so very much. Until next time, stay strong and be free.